Hello, everyone, and welcome to this Fintelekt ABA webinar on cryptocurrency developments in the first half of 2024. My name is Shirish Pathak. I represent Fintelekt, and I'm delighted to be your host today. Our expert speaker today is Calvin Koo, crypto expert and cross-border disputes and investigations lawyer at Kobre Kim LLP, based in Hong Kong. Welcome, Calvin.
Thank you. Pleasure to be here.
So just a few words about Calvin before I hand over to him. For those of you that have not heard him before or seen him before, so amongst a host of other responsibilities, Calvin's work involves counseling financial technology and Web3 clients in high-stakes international litigation and investigations, global dispute resolution campaigns that require highly coordinated multi-jurisdictional activity, tracing digital assets on blockchains, advocating in courtrooms around the world to maximize recovery value, and pursuing both offensive and defensive strategies related to cross-border government enforcement matters and regulatory enforcement actions. Today from Calvin, we will learn about the major developments, regulatory changes in the world of cryptocurrency during the first half of this year. For those of you who attended his last session, you may remember it was, I believe, in the last quarter of last year where he did a wrap up of what happened in 2023. So please connect with Calvin on LinkedIn if you'd like to engage with him and follow him. I would also like to thank the Asian Bankers Association for partnering with Fintelekt again for this webinar. And we have a huge turnout today as well. There will be time for Q&A at the end of the session. So please post any questions you may have in the Q&A window. But before we start, let's run a quick poll to understand, everyone's understanding of crypto. So what is your level of understanding of the cryptocurrency domain, especially as it applies to your role in the compliance industry? So some answers coming in. So you can either be a pro, you could have a moderate level of understanding, you could have a basic level of understanding, or you've just started learning about it, or you're not sure. So let's see what the results show. I think the majority say that they have a basic level of understanding, Calvin, and but you do have a single-digit number of people who are pros, right? Okay, so that's given us a fair understanding of what the audience profile is today. So let's exit the poll, maybe share the results so everyone can see it. Right. All right. So, Calvin, thank you so much for agreeing to be here on this webinar with us today and sharing your thoughts and understanding of this domain. I know it takes a lot of time to prepare for something like this, so we really appreciate that. But over to you.
Great. Well, thank you so much, Shirish, for the kind introduction. Thanks to the entire audience, whether you're a pro or a beginner. Thank you for taking the time to join this webinar. And thank you to the organizers at Fintelekt and Asian Bankers Association for inviting me and putting this together. I'm very happy to once again have this chance to share some observations about the first half of 2024 as it relates to crypto. For those who have had heard me before, you'll know that I'm coming at this issue from the perspective of a legal professional. So I'm not a business or industry analyst, nor am I necessarily advocating for any particular policy position. But for my practice as a cross-border disputes lawyer, I have to familiarize myself with various issues touching on compliance or criminal or regulatory issues. And so through that experience, I have some observations, which I think may be helpful to people of different backgrounds, in-house legal, compliance, investigations professionals, government personnel. So hopefully what we cover today is useful for your own work or even just your own edification. Here at the outset, let me also please give my usual disclaimer, which is that the views I express today are my own, not of my employer. So nothing I say should be taken as legal or financial advice, So of course, please consult your own professionals for such advice. So just getting started, what is the theme of the first half of 2024? And actually, before I do that, let me go back to last time. So end of last year, I said the theme of 2023 was the maturation of the industry. Now, where are we 6 months after that? I think that maturation has really continued, such that governments, institutions, and to some extent, the public have absorbed that. And crypto-related developments are not so dramatically reported in the news. So yes, there are still lots of uncertainties in law, in compliance, in regulation. And yes, there are still lots of bad actors out there that are using cryptocurrency or blockchain technology for nefarious purposes. And yes, there's also still large policy differences among different jurisdictions around the world on how they want to handle those things. These are all issues that continue to evolve and develop. But really, it's the tone, broadly speaking, that I sense a bit of a change. To me, there tends to be less alarm on both sides of the issue of the crypto debate. So for example, for those who think that every aspect of crypto and cryptocurrency is a scam, maybe those feelings still remain, but it's harder to sustain when more governments are establishing regulations and licensing regimes, and more institutional businesses are getting involved with using crypto in different ways. And we'll talk about that today. Also, the fact that many of the biggest named cases that have involved allegations of fraud have been or appear to be soon to resolve, that fact actually takes the temperature down as well. So for example, FTX and the prosecution of Sam Bankman-Fried happened earlier this year. So arguably there's been due process and justice for a case like that and some other similar cases. Now, people can still quibble with the results of those cases, but that's not any different than non-crypto matters, right? Also, there are crimes that continue to happen every day. Things like pig butchering scams, which if you've heard some of my webinars before, we've talked about that. Those are still happening. Those still produce incredibly sad and frustrating stories. And no doubt daily, there continue to be more and more victims. And yet, the number of major news stories that I've seen about those scams or other types of scams around the world has increased dramatically recently. Literally just earlier this week, I saw a long story in the Wall Street Journal about it. And then the following day, there was a different story in the New York Times. So word is getting out about these issues. Hopefully, that type of education to the public will mitigate the volume of these cases. Also, in mitigation, police action. Police forces around the world are getting more educated and know how to tackle these issues better. There's still a lot of challenges, but overall, the situation is building such that 2 years ago, no one knew what these were. I constantly had to explain how these scams worked, what to look out for. Now there tends to be more and more people that understand that and are able to share the warning signs to hopefully prevent future victims. On the pro-crypto side, the march of jurisdiction after jurisdiction adding clarity to their regimes, with the United States being one notable holdout at the present, this further allays fears of outright bans in many places, bans on crypto, bans on facilitating crypto, etc. So instead, there are now more clear paths to legitimacy being created and people seeking out those paths. And finally, frankly, the market for major cryptocurrencies has returned to the extent that that's an indicator of interest in the industry. Bitcoin reached an all-time high of $75,830 US to one Bitcoin. That was back on March 14th. It's gone down a little bit, but it's still quite high compared to about a year and a half ago. So in this first section of the webinar, what I'd like to do is walk through a few different important jurisdictions. Obviously, there's a ton of jurisdictions out there. Everyone's got their own policy choices. So I can't cover everything. And I know there's quite a diverse group on this call, so I'm afraid I can't cover everyone's jurisdiction. But what I can do is try and focus on a few key international jurisdictions and talk to you a little bit about what the regulators are focused on now, and that might be indicative of global trends. Now, I don't want to bore you with the line-by-line specifics of given legislation. For the ones that you're interested in, you can look those up, go to your favorite advisors for local advice applicable to you. But again, let me recap at a higher level some of the trends and focus areas. And I'll start, if you let me, in Hong Kong, which is where I am based. Now, for the Asia Pacific region, this is a key jurisdiction, along with a couple others that I'll mention shortly. Although Hong Kong's domestic market is small, Hong Kong's historical status as a global financial jurisdiction at the doorstep of mainland China has allowed it to develop a robust financial system, including well-respected regulators. This is important for crypto because as crypto becomes integrated into the world financial system, it's finding its way into traditional financial institution business plans, as well as professional investor portfolios. So a city like Hong Kong that runs on these things cannot and has not ignored crypto's potential role in modern finance. To the contrary, and notwithstanding the negative global crypto news from around 2022, 2023, Hong Kong has continue to be one of the few major jurisdictions that, as a policy matter, maintained a bullish approach to courting crypto business development. And it has supported that policy with considered legislation and regulation. So in my last webinar, we talked a little bit about Hong Kong's new virtual asset service provider licensing regime, which began in summer 2023, so exactly a year ago. That basically covered centralized cryptocurrency exchanges and businesses as regulated by the Securities and Futures Commission, which is the local securities regulator. The government signaled then that they would move forward with further legislation and regulatory guidelines, basically in the order of what they saw were priority areas. Consistent with that, in December 2023, the Hong Kong Monetary Authority, which is the Hong Kong Central Bank and banking regulator, so they, along with the Treasury Bureau, issued a joint consultation paper for stablecoin regulations. And that consultation was open for public comment between late December 2023 and the end of February 2024. And just this month, they released the results of that consultation, saying there were 108 submissions from market participants, industry associations, business and professional organizations, and other stakeholders. The government said that, and here I quote, a vast majority of respondents agreed that with the increased prevalence and evolving development of virtual assets, a regulatory regime should be introduced for stablecoin issuers with a view of facilitating proper management of the potential monetary and financial stability risks, as well as providing transparent and suitable guardrails. The proposed regulatory requirements and implementation arrangements received general support from respondents, with some further enhancements suggested in the submissions, end quote. So the government is now on track to finalizing the legislative proposal for implementing the regulatory regime, with a view to introducing the bill into the local legislature as soon as possible, most likely at some point later this year. In the meantime, the government also accepted 3 applicants into the stablecoin regulatory sandbox. Now, some of you may know this, but a sandbox is a period during which regulator bodies allow financial institutions or other startups to test proposed services and products. So these developments underscore the likelihood that financial legislation with accompanying guidelines, including on anti-money laundering compliance, is likely to be passed very soon and come online soon after that. Elsewhere in Hong Kong, the jurisdiction also beat the United States in terms of timeline to approving ETH exchange-traded funds, with a handful of funds launching this past May. ETH is the second most widely used cryptocurrency after Bitcoin. And for a while, there has been market demand for, instead of directly buying ETH, buying an exchange-traded fund on a traditional exchange. And Hong Kong was able to do that a few months ahead of the United States. Now, I defer to the business and investor-minded folks on what they think about that from those perspectives. But from a legal perspective, it was intriguing to me that Hong Kong was trying to get out in front of this opportunity because it's something that requires regulatory approvals. And there had been some concern in the US about whether giving such approvals were compatible with ongoing policy and regulatory enforcement considerations there. Basically, in the US, they were worried that approving a spot ETF like this would be a concession that Ether is not a security, but rather a commodity. And that touches on all sorts of regulatory issues there. Hong Kong was able to get past those issues and push forward so that this came to market earlier. In short, Hong Kong was trying to quickly and efficiently address those legal and regulatory concerns so that business could be conducted. Now, we'll see where Hong Kong turns to next after stablecoins. My understanding is that could be about tokenization, which we'll talk about a little bit later, and then also custody rules as the next priority areas. Now, Hong Kong's not alone in the region in promoting itself as a crypto hub. The UAE and Singapore also have been pushing legislation and licensing regimes, with Dubai within the UAE in particular perceived to be a little bit more bullish in its efforts compared to Singapore right now. Singapore was a hotter location maybe 2 years ago. Now, starting with the UAE, there's some legal complications to cover. There's 7 emirates. There's a federal level UAE set of laws and rules and regulations that would be applicable across all 7 emirates. And then there's also emirate level laws, rules, and regulations specific to each emirate. And frankly, there could be standalone webinar sessions for every relevant sub-jurisdiction. But the one that gets the most buzz in the crypto space, from what I've seen, tends to be the Emirate of Dubai. Now, the Dubai regulator has implemented a comprehensive regulatory framework for digital assets, including provisions on issuing stablecoins. The regulator has granted almost 20 licenses and given initial approvals to dozens more. A couple years ago, Dubai set up the Virtual Assets Regulatory Authority, VARA or VARA, as the sole competent authority for regulating virtual asset activities in Dubai. VARA takes an activity-based approach to regulation and publishes various rule books, which you can find online, covering different regulated virtual asset activities. Each activity has its own rule book, but there are also some general rule books that are applicable across multiple activities. And as I said a moment ago, Dubai isn't the only part of the UAE making a push. Just last month, the Central Bank of UAE approved the issuance of regulations for stablecoin licensing relevant to dirham-backed stablecoin arrangements, so the UAE currency. If it's not that currency, if it's non-dirham-backed stablecoins, that remains under the purview of VARA in Dubai. So details remain outstanding, but it's something to watch as more jurisdictions carve out their regulatory remit. Again, just underscoring the importance and growth that these governments see in aspects of the crypto industry. Now, Singapore. I mentioned at the end of last year that generally, Singapore is trying to balance, like many places, being a crypto hub with emphasizing consumer protection and risks for retail customers. But they're putting particular emphasis on that latter point in the last year or so. Now, even though Singapore as a jurisdiction was earlier than its peer jurisdictions in establishing a licensing framework for virtual asset service providers, This also meant that many prospective licensees have now had the practical experience of going through the Monetary Authority of Singapore's rigorous process, and many are realizing it's no easy task. So like Hong Kong, Singapore last year began pushing through a stablecoin regulation. It has published a proposed regulatory framework, and there is also anticipation that it too will be implemented this year. As with the virtual asset service provider license in Singapore, I would expect that the stablecoin licensing process to also be extremely rigorous in Singapore. Now, unlike Hong Kong or the US, Singapore Exchange's CEO just said this month that the conditions there in Singapore are not ripe for allowing cryptocurrency listings on its exchange. So we're talking about like the ETFs in Hong Kong and the US. So the Singapore Exchange CEO said that it's not yet ripe in the Singaporean ecosystem for that type of product now, citing the need for demand, governance, and structure. But of course, they're open to seeing how things evolve in the future. So they might be a little bit behind on that to the extent that you see that as an important area to push forward. On the other hand, Singapore is ahead with making effective licensing requirements for entities providing custodial services. Now, this was actually legislation that passed way back in 2021, but they just made it effective in April this year. This includes things like user protection and financial stability related requirements on what is called their digital payment tokens and other crypto service providers. This means segregating customer assets, placing them into a trust account for customers so that, if there needs to be redemption or anything blows up, there's access to it, and other requirements which are actually quite familiar to traditional finance and are increasingly a feature of other types of regulations, including the stablecoin regimes that I've been talking about in Singapore, Hong Kong, and Dubai. Also, covering all of this, crypto is inherently a cross-border asset. One challenge for a lot of businesses entering this space is, at least the ones that want to be licensed and follow the appropriate regulations, is if they have a global market, what do they need to do in each jurisdiction to be in compliance? Now, so far, the regulatory status globally is so varied and so new, so there really hasn't been a time or much time to battle test regimes. That's likely going to be necessary before jurisdictions start entering into any sort of mutual recognition or passporting agreements, whereby being licensed in one jurisdiction grants you a license or some level of regulatory approval in another jurisdiction. That will probably come, but it's going to be some time. And until then, businesses likely face extra costs, hurdles, and regulatory uncertainty. And of course, there's also the risk of regulatory arbitrage. So one entity globally that tries to curb such arbitrage is one that's, I'm sure, familiar to many in the audience today, and that's the Financial Actions Task Force. So 5 years ago, FATF issued its first recommendations on virtual assets relevant to anti-money laundering AML-CFT regulations. Global implementation is still lagging in putting those AML-CFT regulations in place. And we know that from FATF's most recent update, which just came out in June, again, something you can find on their website. Let me have a few quotes from their summary of that. There are several governments which have yet to take any significant steps to regulate the sector. And these countries need to prioritize implementing the standards in full as a matter of urgency. Based on 130 FATF mutual evaluation and follow-up reports, 75% of jurisdictions are only partially or not compliant with FATF's requirements. And that's identical to the numbers in April 2023. So this shows, quote, negligible improvement. When focusing on the countries with materially important virtual asset sectors, the picture is better, with the majority having the core measures in place. So it seems like for those jurisdictions that are focused on this space, a lot of them have already done their work. For the rest, this is at best not a priority, and that could be understandable. Different places have different priorities. but at worst, it could be something they are ignoring for different reasons. Now, nevertheless, if this is going back to FATF summary, despite progress made by individual countries, there's still a lot of work to do in order to complete the global system of AML-CFT regulation for the virtual asset sector. And FATF will continue to prioritize closing those gaps. Jurisdictions have made insufficient progress in implementing the travel rule, which is a key AML-CFT measure. Nearly 1/3 of the survey respondents, including some who assessed VA, virtual asset, and virtual asset service provider as high risks, have not yet passed legislation implementing the travel rule. Even among jurisdictions who have passed legislation implementing the travel rule, supervision and enforcement remains low. Now, as a reminder, travel rule is something that requires virtual asset service providers like centralized exchanges to identify the origins and destination of crypto transactions over a certain threshold, much like traditional banking wire transactions. This requires screening and diligence of counterparties, but in the crypto world, there was those extra hurdles of the pseudonymous nature of counterparties of many transactions. Now, the slow progress in regulating the virtual asset sector is a serious concern. This, again, is FATF's summary, as virtual assets continue to be used to support the proliferation of weapons of mass destruction, including by North Korea, as well as by scammers, terrorist groups, and other illicit actors. FATF's report nevertheless acknowledges positive developments in the virtual asset sector reported by the private sector, such as increases in the virtual asset transaction volume using travel rule compliance tools, and in virtual asset service providers considering travel rule obligations in their operations. So this report highlights that all players need to have an appropriate risk identification and mitigation measures and continue to work towards fully compliant travel rule compliance tools. So a lot of the private sector is doing a pretty good job of onboarding these tools that are becoming available to meet these global obligations. Moving on to FATF's identified risk areas, they say, while DeFi arrangements, decentralized finance, DeFi arrangements still account for a relatively low percentage of overall virtual asset activity, the report notes that the need to monitor such arrangements for illicit finance risks. The report also recognizes the increased adoption and use of stablecoins, including for illicit activities, so FATF will continue to monitor those risks. Right, so just to underscore that, FATF is highlighting the use of crypto to support terrorism, scams, other criminal activity, and then specifically points out that there's this mass adoption of virtual assets, including stablecoins, which could allow or potentially decrease the use of AML-CFT obliged entities, right? So right now, traditional finance, the plumbing in the global financial system, these entities have their AML requirements. FATF is concerned that the shift to crypto might mean going through finance plumbing that doesn't have these obligations because, as we just discussed, entities and countries are still coming on board with these requirements. And so FATF talks about stable coins, which are used for that. So while at first it may seem incongruous that FATF is sounding the alarm over the use of stable coins as part of illegal activity, and then you have governments courting that technology, seems in opposition at first, but actually these are operating in concert, right? Because it's just an objective recognition of reality that cryptocurrency, including stable coins in particular, are being used for all sorts of financial transactions now, both legitimate and illegitimate. So that being the case, you can see why certain governments are prioritizing putting stablecoin regulations in place. And these regulations typically include the AML-CFT requirements that are aligned with FATF and traditional finance. So for example, going back to the Hong Kong stablecoin proposal I mentioned, that specifically refers to travel rule requirements in line with FATF standards and local AML legislation. So it's all being incorporated in the laws and regulation. So if these are going to be used widely, stablecoins, I mean, then they should be done in a controlled manner. That's the philosophy. Now, putting up regulations, it's not a silver bullet. As noted before, there's still global regulatory gaps, and the nature of this technology means there are other risks that remain. But ultimately, crypto is not going away. I think we can see that now after a few years. So this multi-front approach of regulation, AML requirements for centralized entity and licensees, better public education, more funds for law enforcement, and eventually jurisdictional cooperation will hopefully mitigate the illicit activity to a manageable level down the road. Let me spend a little bit of time on the United States, which remains still an outlier in terms of progressing clear crypto legislation and regulations. Now, those who have followed me before know that the headline theme for US regulations is regulation by enforcement, bringing civil, in some cases, criminal legal action to make clear where the boundaries of the law are. Now, as I just said, in some cases, there's actual criminal prosecution by the Department of Justice for clear-cut allegations of criminal activity. So most notably, earlier this year was the dramatic trial of Sam Bankman-Fried of FTX infamy. A jury found him guilty on 7 counts of fraud and conspiracy stemming from that 2022 FTX collapse, which prosecutors called one of the biggest financial frauds in US history, involving theft of $8 billion with a B, US dollars from customers. And the judge sentenced him to 25 years in prison. Now, luckily for FTX creditors, in frankly a shocking twist that people didn't expect when the collapse happened, creditors in the bankruptcy will recover 100 cents to the dollar of what assets they had with FTX at the time. Some might even get more based on interest. FTX reported that it owes 11 billion US dollars to creditors, but that it has between 14.5 to 16.3 billion dollars to distribute. Now, there are people, some FTX customers that complain that this doesn't account for the gains in the value of Bitcoin and other cryptocurrencies since the collapse. So for example, at the time of the collapse, Bitcoin was worth 16,000 US dollars to one Bitcoin, and today it's close to 66,000. The recovery in the bankruptcy is going to be in dollars, not on the Bitcoin itself that was used or that was deposited, and this is just how bankruptcy procedure works. But frankly, when the collapse happened, most initially expected 0 or very small amounts of recovery. So this is a positive result for creditors. How did they do this? Well, FTX, or the estate, the bankruptcy estate, was able to recover funds by monetizing a collection of assets, including proprietary investments held by FTX-related businesses. So as the value of those assets went up over the last couple of years, so did the pool of recovery. Now, outside of that, there are also ongoing high-profile regulatory enforcement cases driven by the US securities regulator, the Securities and Exchange Commission, SEC, which views all cryptocurrency except for Bitcoin as a security and therefore under its regulatory remit. And it says this based on security laws that were written in the 1930s. Now, over the last year, the SEC has brought more enforcement cases against many of the industry's biggest names, including Binance and Coinbase. And these are largely based on the notion that big centralized crypto companies operating in the US or selling to the US market failed to register as a securities exchange or as a securities broker or dealer. Usually the primary claim isn't fraud as such, but rather it's a regulatory violation for failing to register, which would be required for securities-related businesses. Still, the impact on a business is significant. And at one extreme end, there could be significant financial penalties or even an injunction that could basically force a business to be closed. So while the SEC's enforcement actions have had some successes, there's also been pushback from many defendants, many of whom are now financially well-armed and with many supporters. The SEC has also aggressively pursued these cases against some entities inside the courtroom, meaning it's reached the stage of their investigation and enforcement where it's actually being litigated in court. Noticeably, it stood down from some of those actions, but within the courtroom, there have been victories on both sides. At issue often is the SEC's theory that everything is a security. This is being well tested before judges in many US jurisdictions. But so far, the conclusions are not consistent. Most of these courtroom decisions right now are still at the trial court level, so they're not yet binding law across the US. That's going to require an appellate court decision, and even then it would only apply to the relevant jurisdiction over which those appellate courts sit. So in short, the law remains unclear in the US. Now, some members of the US Congress have tried to address this. For example, in May, there was a bill put forward called FIT 21, which stands for the Financial Innovation and Technology in the 21st Century. This was an effort to provide regulatory clarity by dividing up regulatory oversight in the US between the SEC and the commodities regulator, the CFTC. Now, although it passed with support from both Republicans and Democrats in the House of Representatives, its fate in the Senate chamber, which is the next step of passing a law, is less clear. And even if it passes the Senate, it would then have to go to the president as the final step for passing the law. And I'm sure you all know that we're only months away from the next US presidential election. And I'm sure many here have their own guesses on how it'll turn out. I think fair to say right now, it's still a pretty close call, even if you might feel confident one way or the other. Whatever the outcome, there will be lots of attention paid from within the industry to what impact this has on crypto policy in the US moving forward. It might have a dramatic impact. I'll return to this future prediction in a moment when we get to the last section. But just sticking with the present right now, let me move now to some observations from the industry in response to all these government regulations and how things have evolved. Now, from what I've seen, my observations are actually quite similar to what I said 6 months ago on the last webinar. But at a high level, for those who didn't attend then or who don't recall, from my anecdotal observations, there was a marked change from 2022 and 2023. So going back in time in past years, there are a lot of startups eager to monetize and make money quickly. They focused on cryptocurrency and digital tokens, and NFTs were really big a couple of years ago, as I'm sure folks will remember. But now, in this past year or so, there's more talk of real-world use cases on the blockchain technology, with 5 to 10-year time horizons for being viable businesses. There's a recognition of the need for regulation, inquiries about how to follow regulation, where's the best place to get a license, things like that. And that's largely from the startup side. And then from the institutional side, I'm seeing more matter-of-fact recognition that this industry and this technology is a piece of the global financial world. Some institutions want to be a leader in it. Others are happy to just diversify their asset holdings and services for that. Either way, in some ways, the technology has lost some of its buzz, largely to, say, artificial intelligence, AI. And it's now, if you like, a boring, diverse asset class. Now, that's exaggerated language, of course, but the point is, as I said at the outset, the tone in conversations about cryptocurrency is, to me, so different than even a year or two ago. It's becoming quite normalized. So now a couple minutes on looking forward to the rest of 2024, and then we'll turn to some questions. So please post those if you have any. I think for the next half of the year, we're just going to continue on developments in government legislation and regulation around the world, largely driven by institutional demand for rules and regulations. Continued move towards putting up guardrails around stablecoins. So as I said, Hong Kong and Singapore are probably going to finalize that legislation. Other jurisdictions will develop theirs. The next priority for many places might be on tokenization, which is a digital representation of a real thing, a real asset, for more easy holding and transacting on the blockchain. Proponents will say that touts its ability to put an ownership record of a traditional asset on the blockchain to enhance liquidity and efficiency. Either way, again, whether or not you think there'll be a large demand for that, I think it's reaching a point where there's enough businesses and consumers looking into this that governments will have to start thinking about how to regulate that. Also, rules on custody. We talked about Singapore doing that. But this really goes to the heart of the plumbing that's required for digital assets to move smoothly among people and entities within and outside a jurisdiction. So I'm sure many people in the audience today who work in different aspects of finance or payment services, they understand, sort of the nitty-gritty of how money moves, right, across the world. But I think if you talk to friends or family members outside of the industry, many people don't think about how money moves from one person through a bank or credit institution, through a payment service provider, to the other side, people and entities holding temporary custody or having certain responsibilities of those assets or funds along the way, right? So, like most people, if I go to Starbucks, I tap my credit card, I leave with my coffee, I don't really think about how my money went to Starbucks, right? But really, there's a whole step-by-step process, right? Going through the card, who's tied to a bank, and then there's processing services, and then it's got a reverse on the other side where it gets to Starbucks bank, right? So crypto needs the same type of regulation covering all those steps of plumbing along the way. And finally, again, we talked a little about ETF and trading approvals. I think more places are going to start looking at whether that's appropriate for their jurisdiction, right? Putting those types of ETFs on traditional markets that are backed or refer to cryptocurrency, at least the larger cryptocurrencies by market cap. Just mentioned the US. I think we'll see some maybe additional regulatory clarity in the US, which would be an important market development, not just for the US, but just because of the size of the US market, it has an influence around the world. We talked a little bit about the presidential administration shift. So we now know that there will be a different president. The common perception is that if Trump wins, there might be a bigger change in policy and laws perceived to be more crypto friendly. But I think even if it ends up being Harris, she might have a different view than Biden on the direction of the policy, and a different view than the current securities regulator, Chair Gensler, about how to regulate these things. So we'll see. There might also be the conclusion or at least substantial material progress in some of those big enforcement cases that I mentioned. Industry, I think compliance tools, tracing tools, those are going to continue to develop, right? The laws are developing such that businesses involved in this space need to implement compliance and AML tools relevant to crypto. Those businesses need those tools, right? So now there's a demand for people to provide those tools. And so I think that's just going to be an area that's going to continue to grow, fitting the different needs of different types of service providers around the world. And then again, I mentioned this a couple of times, but law enforcement, their understanding of some of the problem areas, how to tackle those problem areas, their education has really gone up, and they're helping to educate the public as well. So for the places that are able to have a larger budget focused on these resources, I think that can help tackle some of the illicit problems that continue in this space. Anyway, I've been talking for a long time. Let me pause there, see if there's any questions from the audience.
Right. Calvin, thank you so much for that very informative and engaging presentation. We do have a few questions from the audience. So one is from Vijay Bharadwaj from Singapore. Vijay, good to see you online. So he really has two questions, one on the institutional side and one on the retail customer side. So the one on the institutional side is, he says, I am seeing that regulators are increasingly looking at the experience and knowledge of the senior management team and the board in the crypto and digital payment token space. Having experience in traditional finance is not good enough to get a crypto license. How do you see this evolving globally from a regulatory standpoint? And on the retail customer side, he says, do you see regulators putting in place suitability requirements while allowing retail customers access to crypto or DPT given the associated risks?
Great questions. And I think those are very perceptive observations, which I've seen as well. So taking them in turn, on the institutional side, I think you're right. What a lot of regulators have done is try and adopt the standards they see in traditional finance, right? And the rules that are already in place by securities regulators and central banks regulating banks and financial institutions. So one of those things, as you mentioned, is senior management has to have the right level of experience. And then you're right, it's a chicken and egg problem, right? How can they have had sufficient experience in an industry that's so new? There's no silver bullet answer for that. right? The guidelines say what they do, and the regulators have a specific preference. And then it's kind of, frankly, an ongoing balancing act as these applications come through, right? One extreme would be nobody has the relevant experience, right? You're all saying that you're senior management in traditional finance, but you've done nothing in crypto, so we're not going to prove anything. Just as a hypothetical, that's one potential outcome. But it's not that practical for the places that actually want to develop an actual live crypto industry, right? So it's going to be a bit of a give and take, I think, as more applicants go through the process, and maybe they'll find the right level, right in quotes, level that is satisfactory to the regulators. Many regulators are still on the cautious side, given how things blew up a couple years ago, and they certainly don't want to feel like they're going to be criticized for letting licenses and activities through that end up going south. But again, at the same time, I think you hear from policymakers that there's encouragement to make sure that something is done to allow business to go forward. So I think that kind of chicken and egg problem is going to be replicated in other jurisdictions. Maybe if one or two or three start to solve the best case, then others can follow. But that's definitely something to watch. And then on retail side, suitability requirements. You also see this. It sounds like you've seen this. Some places say we got to focus on professional investors at first, and then only if the entity that wants to trade is within the jurisdiction, then we're going to allow them to sell to retail customers, but then have all these requirements about warnings and cautions, right? So what they're doing is making sure that, okay, professional investors can still have access to these big cryptocurrencies. But if you want to do it to the retail folks, the person or entity that's issuing and trading to them, they need to be within the bounds of this jurisdiction. So if anything goes wrong, we can resolve that, whether it means getting the money back, whether it means prosecution, et cetera, so that the government isn't left without any, or being seen to be left without any recourse of something that happened offshore. So anyway, I think that those are the trends in those two areas. So that was a good question. Hopefully that answers some of your thoughts.
Right. Thanks, Calvin. We have one more question from Jose Antonio, who asks, what are the additional regulations that you see coming down the line from the FATF?
From what? I'm sorry, the last part of that question?
What are the additional regulations that you see coming down the line from the Financial Action Task Force?
Oh, from FATF. So I think the two things are, they're going to keep focusing heavily on this travel rule and trying to get these different jurisdictions that are behind on it to really implement that. So that's not new, but I think you can sense if you read their update frustration that that's not being implemented as quickly or not being prioritized by many places. And then the next thing will be those areas that it mentioned as risk concerns, stable coins, and decentralized finance, right? So it may be all well and good and easy to try and get the travel rule applied to centralized entities, centralized crypto exchanges, right? Because that's not that different than traditional finance, right? You have an entity with a headquarters, with a compliance department that is subject to local laws and regulations that should have the systems in place, or the ability to put systems in place to do customer checks and record the information required for travel rules. But what about the increased use of decentralized finance, where there isn't, in its most pure form, a headquarters or a company that has a headquarters or incorporation in any jurisdiction? It's just computer code. It's an algorithm that's causing these transactions to happen. How do you make them, whatever them is, or it, if you want to refer to the code, ensure that there is relevant travel rule or travel rule equivalent information being recorded? I think that's going to be a challenge. I think if the FATF can figure out ways to adopt to that type of system, that will be something they'll push forward. And then short of that, or maybe parallel to that, talking with governments about what do we want to do about decentralized finance, right? Again, just to take the extreme example, just as a way to frame it in your mind, right? Is there a way to like outright ban it, right? So that we can force every transaction to go through centralized entities that have these obligations. Obviously, much easier said than done, but that's one extreme. It also may go against some policy wishes for those who are trying to encourage business. So again, ongoing calibration of policy, of consumer protection, of AML requirements. Where does this all land? Every jurisdiction's trying to find the sweet spot, and they're going at it their own paces and own ways. So it'll be a while before there's broad consistency.
Right, thanks, Calvin. Okay, before we take the next couple of questions, let's run another poll for the audience. Can we have the poll up, please? That will also give Calvin some breathing time. All right, so this one is, how would you rate your organization's preparedness to handle compliance challenges associated with crypto transactions? All right, we have a fair number of responses, some still coming in. Meanwhile, while these responses come in, and before we take the next question, can we have some information on our next workshops displayed? All right, so our next Fintelekt ABA virtual workshop is going to be on the detection and prevention of money mule accounts. That's going to happen on the 27th of August, 2024, after which we have advanced trade monitoring using real life case studies, a workshop happening in Kathmandu in Nepal. That's an in-person workshop. Our quarterly FCAT training this quarter will happen on the 26th and 27th September in Thailand, in Bangkok. And for those of you tuning in from the Philippines today, our next in-person workshop will be at the Makati Diamond Residences in Manila on effective sanctions compliance, the priorities and implementations in that. So please visit our website for that. And those of you who are attending from India today, our next annual summit, the 13th annual summit, will happen on the 27th of November in Mumbai. So all of this is there on our website. Please feel free to go and take a look and register for what might be of interest to you. Let's quickly see the poll results now, if possible. Okay, so about 11% of the audience says that they're fully ready to handle any compliance challenges associated with crypto transactions. That's great. All of you who would like to share your best practices in this, please connect with us, and maybe we'll get you onto the next webinar also as speakers. And there are about 90% others who are in stages of doing that. All right, Calvin, what's your reaction to this?
I was going to say that's encouraging, and that's actually consistent with some of my observations, I think, earlier, which is that this is becoming a standard part of a lot of institutions, a lot of businesses. There's just a recognition that this is not just a flash in the pan technology that's going to go away, right? Everyone has to start building this as part of their business. And it's great to see that many have started preparing and some seem to be quite ahead. So that's good news.
Right, right. All right. So we have one more question which says, do you see client asset segregation requirements in other jurisdictions after the FTX fallout? And are these prescriptive or more principle based in your observation?
Yeah, I think that's going to be a big one, especially because of the fallout. So I mentioned FTX, the global platform. In some ways, they got a little bit lucky that the people are going to get 100 cents on the dollar, right? At the beginning, people thought that they weren't going to get anything or very little. There was one sort of asterisk to that. FTX Japan was a separate platform than the global FTX. In Japan, which had its own crypto exchange collapse a few years prior, Mt. Gox, I think, had already put in place before the FTX collapse segregation requirements. And so very quickly after this all fell apart, customers of FTX Japan were confident we're going to be able to get back their assets. So I think that lesson was extremely and entirely informative to where these new regulations are going to be, which, as you say, is customer segregation. And on top of that, some other requirements in terms of what's required for backing. So for example, some of the stablecoin legislation, right? Great, you want to issue a new stablecoin? Here's how you do it. But when you do it, you have to have sufficient asset reserves that are segregated from your own company's reserves, so that if something falls apart, if the stabilization mechanism falls apart, and people who hold the token want to redeem their token for what you said was going to be 1-to-1 to the US dollar, you, stablecoin issuer, have the full asset reserves of, however million US dollars in place, so that you can give it back and have those redeemed. So I think entirely that type of segregation and asset backing is going to be a feature of many of these regulations that we see going forward.
Right. Thanks, Calvin. All right, let's take one last question in the interest of time. This is from Ranjit. Ranjit, good to see you online. He says, for financial crime compliance professionals wanting to work in the virtual asset space, which are the countries or geographies that you feel would be best to try and look for opportunities?
Wow. Gosh, I don't know if I'm the most well qualified, because there's a couple different factors, right? So it depends. What are one factor obviously would be which jurisdictions are actually engaged in terms of their financial crimes compliance teams in focusing on these issues, right? And is there law enforcement focused on this, or are there internal departments and businesses that are focused on it? I think one way to look at it is those jurisdictions that are talking about that are developing regulations more broadly. This piece has to be part of that, meaning their legislation will require these businesses to have financial crimes compliance departments in place and investigators. These jurisdictions will need their police departments and regulators to be educated on investigating these types of issues. And frankly, some of the jurisdictions we talked about tend to be jurisdictions that have bigger budgets for these kind of things. So maybe that's the place to start. That being said, if you go the other way, there's many jurisdictions where crypto is very active right now in terms of day-to-day transfers. And there's not a lot of government oversight yet. So maybe there are individual businesses out there that need help because the government isn't there right now to be able to step in and assist, but their business needs that kind of help. So that might be a place to explore too. So if you're looking, good luck on looking on those places.
Well, thanks, Calvin, for the session today and for all the preparation that you did to share with our audience. Audience members, thank you so much for being online for an hour. I'm sure it was very useful for you listening to Calvin. My sincere thanks to the Asian Bankers Association, Meg Moreno, and other friends there. And again, Calvin, thank you so much, for being here. And I look forward to your next session with us at the end of this year, when we will do our annual roundup of the crypto industry. Right.
Great. I look forward to it.
Absolutely. Thanks, Calvin. You have a good day.
Thank you, everybody. Thanks, team. Thank you.
Bye.
Have a good day.